A question's been raised whether Prop 54 and the 72-hour imprint rule can be waived. Now, Proposition 54 was enacted by California's voters at the November 2016 general election, and it adopted both constitutional and statutory changes dealing with bill amendments and recordings of legislative proceedings. The proponents of Prop 54 in their ballot arguments were specifically concerned with so-called gut and amend bills that contain, quote, last minute amendments to bills that are frequently used to push through political favors without comment or with little advance notice. Moreover, complex bills are often passed before members of the legislature have any realistic opportunity to review or debate them, resulting in ill considered legislation, unquote. So in Article 4, Section 8, it was amended by Prop 54 basically to provide that no bill may be passed or ultimately become a statute unless the bill with any amendments has been printed, distributed to the members, and published on the internet in its final form for at least 72 hours before the vote, except that this notice period may be waived if the governor has submitted to the legislature a written statement that dispensing with this notice period for that bill is necessary to address a state of emergency as defined in paragraph 2 of subdivision C of section 3 of Article 13B that has been declared by the governor, and the House considering the bill thereafter dispenses with the notice period for that bill in a separate roll call vote entered in the journal, two-thirds of the membership concurring prior to the vote on the bill. As a result of Prop 54's changes to Article 4, Section 8B2, the final form of bills must be in print for at least 72 hours, which is basically deemed to be publication on the internet before the bills can be voted on by legislators on the floors of the state assembly and state senate. Now, two common questions are being raised at this time. First, does Prop 54 apply to all legislative measures, bills, constitutional amendments, and resolutions? The answer is no, it only applies to bills by the language in Article 4, Section 8B2. So bills create statutes or bills place bond measures on the ballot, but Prop 54 does not apply to a resolution, nor an Assembly constitutional amendment or Senate constitutional amendment. The second question is, can Prop 54 be waived for legislative ballot measure deals, for example? I don't think so. The provision in Article 4, Section 8B2 has only one instance in which it can be waived, a gubernatorial written statement to the legislature that dispensing with the 72 hours is necessary to address a state emergency, which is defined in Article 13B, Section 3C2, and a two-thirds vote of both houses is required. Now, the term emergency is defined as, quote, the existence, as declared by the governor, of conditions of disaster or of extreme peril to the safety of persons and property within the state or parts thereof, caused by such conditions as attack or probable or imminent attack by an enemy of the United States, fire, flood, drought, storm, civil disorder, earthquake, or volcanic eruption, unquote. This limited instance does not appear to apply to a legislative deal on one or more pending ballot measures. So, by the way, the only time that this exception has taken place from the 72-hour imprint rule was on Monday, March 16th, 2020, to deal with the COVID-19 pandemic. And it was used specifically for two bills that were enacted and sent to the governor regarding emergency spending during the pandemic.